Hi, this is Kathleen Bonzik, and last week the United States Equal Employment Opportunity Commission released its enforcement statistics for fiscal year 2015. And to no big surprise to me and to many others, the number one charge received by the EEOC involved retaliation. And this is where applicants and employees filed a charge of discrimination against their employers or prospective employers and alleged that they were retaliated against for opposing some sort of discrimination, or they suffered retaliation at the hands of their prospective employers or employers. Why is retaliation the number one most cited charge pursuant to the EEOC? Something like 44.5% of all charges received last year by the EEOC involved retaliation. The number one reason, in my opinion, is the Sheila White case. This is the standard that was established in 2006 when the United States Supreme Court entered its ruling in the landmark case of Burlington Northern versus White. It is the standard in this country for retaliation. And what happened in that case? Sheila White was an employee of the Burlington Northern organization in Tennessee, Maintenance of Way organization, and she was working as a forklift driver. And at some point during her employment there, she says she suffered discrimination and she complained about it. And after she complained about it, she was taken off of her job as a forklift driver and transferred into a position that was less desirable. It involved cleaning the railroad tracks. It was dirtier, it was grittier, and it was less prestigious than the forklift driver position was. In addition, Ms. White alleged that she was improperly suspended, and she was suspended without pay, and later on, that suspension was reversed. So she got all her money back, and she was later reinstated into her position. There was no adverse ultimate employment action that was taken, meaning she was not demoted. She did not receive a loss in pay. She did not receive a loss in benefits. She was certainly not fired. And at one point in this country, before the Supreme Court entertained her case, the appellate courts were split. Some appellate courts stated that in order to sustain successfully a retaliation claim under Title VII of the Civil Rights Act, which is the cause of action that Ms. White brought, the plaintiff would need to show that he or she suffered a negative loss in pay, in benefits, something involving an ultimate employment decision. Other appellate courts said no, that was not required. The Supreme Court agreed. The Supreme Court, in its ruling in June 2006, determined that in order to be actionable, unlawful retaliation, a plaintiff need only show the following. A plaintiff need only show that the action that's being challenged would dissuade a reasonable worker from making or supporting a charge of discrimination. That is a very plaintiff-friendly standard, and that is the standard for retaliation that's been the law in this country since 2006, and in my opinion, this is the reason why we are seeing so many retaliation charges, and we're going to continue to see them in the future. This is Kathleen Bonzik. Thank you for watching and for listening today.